look at the relationship between law and power in the interstices of administration, the day-to-day work that governments do. And if we're going to be interested in the rule of law, then we should focus our attention on the role of law in the day-to-day operation of governments, and that is indeed the domain of administrative law and the focus of our next panel. We are very pleased to have two presenters who bring very extensive on-the-ground experience with the legal system in Iraq, and I would like to introduce them to you in the order that they will speak. They will talk each for about 15 minutes, and then we will open this up for your questions and dialogue. Our first speaker, Haider Hammoudi, is an associate professor at the University of Pittsburgh Law School. His scholarship focuses on Middle Eastern and Islamic law in particular. He has worked full-time in Baghdad, advising the Constitutional Review Committee of the Iraqi legislature, and helped develop critical amendments to the Iraq Constitution and advised on a variety of other pieces of legislation, including hydrocarbons law, revenue management law, and antitrust law. He has his undergraduate degree from the Massachusetts Institute of Technology and his law degree from Columbia Law School. Our next speaker will be Sabah Juma al-Bawi, who is the head of the Office of Legislative Drafting in Baghdad, where he acts as legislative drafter to the Constitutional Review Committee for the Iraqi Council. He has conducted extensive legislative research related to the new constitution and legal system in Iraq. He was a lecturer at the Salahuddin University in the Kurdistan region from 1999 to 2006 and holds a PhD in constitutional law and political systems. With that, I'm going to turn it over, Haider, to you. Thank you.
Thank you. Thank you very much. Thank you to the University of Pennsylvania for helping organize this and for giving me the opportunity to do the one thing I wanted to do in Philadelphia since I was about 7, which had nothing to do with independence, Liberty Bells, or constitutions, but running from my hotel over to the Museum of Art and doing this, and then running back. Unfortunately, in the 4-mile trip, I may have taken a little, in my excitement, I may have gone a little bit faster than I should have. So if at any point I slump over and start vomiting uncontrollably, it has nothing to do with any of you or the nature of any questions asked. With that, I guess I should start by pointing out where I think that my perspective differs, and when we're talking about administrative law and effective governance, I think it's important to talk about this different perspective between me and some of the speakers who've come previously, because I think the difference in perspective is actually quite stark, and I would describe myself as disagreeing with substantial portions of much of what preceded, other than Ambassador Sarabadi's point that I think he's too much of a formalist, because that part is definitely true. Although I very much like Ambassador Sarabadi, and in fact, it's too bad he's not here, because I wanted to tell him I'm attempting to sabotage his attempt to re-enter the Foreign Service in Iraq, because I do need him in the academy. He helps keep me honest, and I think he's one of the most able people writing about Iraqi law. But the problem, I think, with some of the approaches is one that's really dominated by a formalism. And a formalism that I don't think would be taken as seriously by substantial portions of the American legal academy or the American practice as it is in the case of Iraq. If we could focus for just a second on the power to tax, which was discussed that the Constitution doesn't grant the federal government the power to tax. You could make precisely that argument about the power to issue paper money on the part of the United States federal government, by which I mean that if you went into the Constitution, you won't find it in Congress's enumerated powers. If you go into the negotiations over the constitutional text, you will see a specific enumerated power that has been taken out of the American Constitution. If you read the Federalist Papers, it is amply clear that the power to issue paper money isn't present in the United States Constitution. Now, we could do the same thing with the power to tax in the Iraqi Constitution. And there's really two ways to take it. One is to adopt what I believe was, with respect to a few of the speakers who came before me, a formalist approach, and that would be to say, oh, this is a flaw, we have to fix this, we have to amend this, and every single time something comes along that doesn't seem to accommodate what we like, to sort of say, this is a problem, we have to fix everything. Or we could adopt what I would call a realist approach, one that I would advocate, which is to say that language is elastic and understandings change over time, and that flexibility in language and what is considered vague in a constitution in some ways is beneficial. Article 112, in my opinion, is vague, but that vagueness is beneficial. It grants, it can clearly be constructed in a way that grants to the central government a power, and it can be constructed in a way that does not. That vagueness creates flexibility. And to the extent that one takes seriously constitutional practice as an essential and elemental part of constitutionalism, it is the power to tax or the power to issue paper money in the Iraqi context and the American context are largely the same, by which I mean that the Iraqi government has issued taxation laws. It has issued taxation laws after 2005. It has issued them with the support of the Kurdish contingent in the Iraqi legislature. The Iraqi taxation authorities collect money. Nobody really challenges this. The federal Supreme Court has never heard a case about this. Now, we could worry about this, and we could worry about provinces forming regions, and we could, I guess, worry about whether or not, at some point, given the absolute clarity on the same formal requirements respecting the issuing of congressional power to issue paper money, that at some point the state of Ohio is going to declare that actually US dollar bills are no longer valid and issue this before the Supreme Court. Somehow the Supreme Court's going to agree with this. Or we could say, look, there is constitutional praxis. Praxis matters. Traditions matter. And developments on the ground matter. And those developments on the ground in Iraq, I think, point to the very types of things that both Ambassador Stirabadi and Ambassador Rahim were asking about, or calling for, which is an asymmetric form of federalism, which is a Supreme Court that is composed entirely of secular judges, in which no other judges are being formed, right? And which, or Islamic judges don't play a role, and in which the role of Islam as a sort of a supervisory legislature doesn't really exist. With that sort of 5-minute introduction of what I mean by realism, what I mean by sort of focusing on the way that things work on the ground, let me sort of turn now to where I think things, and I think it was discussed as a bottom-up perspective, might be effective and where they might not be effective, and where things might be working and where things might not be working. Because I think I'm a little more sanguine, and I think the picture's a little more mixed than others. I do think that when it comes to the matter of the judiciary, by and large, with respect to civil matters, protection of property rights in particular, that there is a decided decidedly positive outlook. You do have a tradition of the enforcement of property rights generally. You do have a reasonably developed civil code. Even when it comes to the issue of foreign investment, one doesn't imagine, you do, by the way, have the enforcement by the judiciary during the Saddam era. And there are Court of Cassation cases about this, even during the Saddam era, wherein a foreign investor in Iraq or a foreign contractor in Iraq calls for arbitration under UNCTAD rules, and it's contained in the contract, and the Supreme Court actually does, the Court of Cassation has actually referred those cases to arbitration. So you have a lot of positive outlooks. I completely agree with what somebody in the previous panel said, that the New York Arbitration Convention would help. But again, we'd be talking about another text. What would matter is the judicial practice, and it does seem as if judges are reasonably open to and desirous of protecting in significant ways property rights, and that they tend to work reasonably effectively. That side of administration and administrative law, I think, is largely helpful. And to me, really, the key element of that is respect for arbitral procedures. The reality is, particularly when you're talking about foreign investment, and I just want to focus on foreign investment for a second, you do have a desire generally by foreign investors, wherever they are, And this really would be including an American foreign investor in France, where there's no real question about the integrity of the judicial system. Nobody really wants to plead in a foreign country. And so generally speaking, what dominates is international arbitration. The judicial mechanisms generally seem to respect it. The investment law, by the way, while not being the New York Convention of Arbitration, enacts a very similar provision. The Iraqi legislators that I have spoken to when I've been talking about the importance of the New York Convention almost invariably point to this and say, well, it's basically the same thing and this is more organic to us. I think what they'll learn, in my opinion, is what the Qatari legislature, or the Qatari really executive authorities learned when I spoke to them, and they said the same thing, which is you can have a really nice law, it can be a really pretty law, it might do everything that you think, and it might very well fit within your organic structures. But the New York Convention for the Enforcement of Arbitral Awards is just the market standard, and that over 100 countries have adopted this standard. And because over 100 countries have adopted this standard, you do have a sort of an expectation that it gets adopted, and it's sort of an important market signal. So my guess is that eventually that will come to be. But aside from that, really the problem, I don't think, are the judicial mechanisms when we're talking about the enforcement of arbitral awards. I think, and I'll try to get to this at the end if I have time, but the enforcement of constitutional rights might be a little bit more problematic. But certainly when it comes to issues such as investment, you don't have a problem. You do have a problem with criminal administration. I think that has been justly and amply criticized. Again, looking at text, you don't necessarily have a problem. You have effectively a French criminal procedure code. What you do have as a matter of praxis, by just about anybody who's looked at it, is a system that tends to rely extremely heavily on confessions, and the attempts by various international organizations and institutions, from the US military to various non-governmental organizations, to introduce things like forensic evidence, in my opinion, have not been broadly availing. Obviously they've been used in cases in which, specific cases, but by and large they've been broadly availing. And you have a system that continues to use and rely upon confessions, and the result of that is a system that tends to coerce confessions, frankly. And that continues to be a problem within Iraqi criminal enforcement. So where does the problem lie? Why do we not have the huge numbers of foreign investment that we would expect? And the numbers are actually kind of disappointingly low. They're disappointingly low after the passage of a pretty good investment law. And I won't say a wonderful judiciary, but by the standards of developing nations, certainly in light of the challenges that Iraq faces, not terribly bad. The problem really lies in the fact that whether you're interested in vindicating a foreign investment, or you're interested in getting electricity power plants running, or you're interested in vindicating an individual right, in a great number of cases, the really effective way to do that is to work through the administrative processes of a thoroughly bureaucratized state. And as we've discussed, Iraq is a thoroughly bureaucratized state. You have ministries, you have institutions. All of these things are very much in play. The problem is that bureaucratized state is extreme. Well, first of all, the bureaucracy is too big. It's sclerotic. It has a number of outdated elements. If I could, and I'll spend my remaining 5 minutes just focusing on some of the issues. I advised and do a fair amount of advising of Iraqi, those interested in investment in Iraq, and one was interested in some sort of fertilizer company, and we had to advise on the types of permits that they needed. We did a very thorough review of those and came up with literally something like 59 permits. And it was permits for, everything. Permits in order to open the project for electricity. Then you had to go permits for telephones, permits to bring in any sort of equipment, inspection, scientific inspection of anything that cost over a certain amount of money. You had permits for insurance. You had permits to hire Iraqi workers that you had to go through the pensions law to go vindicate. You had licenses that you needed in order to hire foreign workers, and you need separate licenses in order to have the foreign workers reside in Iraq. Two separate processes. You need licenses in order to export foreign currency. It's protected. You have the right to export foreign currency, but you need licenses in order to vindicate these things. So you need licenses and permits and processes, and you have to go to different ministries, more often than not in Baghdad. Does everybody actually go to Baghdad, or do they ignore some of this? Who knows? But I mean, to the point that we're talking about rule of law and ignoring various rules is not exactly what we're seeking to vindicate. To the extent that one takes the rule seriously, one has to go to Baghdad. The processes tend to be extremely time-consuming, both in personal experience and in advising. They're extremely time-consuming. They're extremely difficult to manage, and the result of all of that is that it is a vehicle for some level of corruption. In order to get the permits, you tend to bribe your way through them. It takes a fair amount of time to do it, and it takes a fair amount of effort. And the third problem really is, and it's something that Ambassador Sturabadi had pointed to, and I think he's right about, which is you have Saddam-era regulations. And I'm not thinking about Saddam-era laws that are particularly, but really things that are sort of reflective of a socialist state. I say socialist hesitantly because I know it's used a lot on, to promote particular agendas within the United States. But within this, we're talking about a former socialist state, and we are talking about rules that can be, and processes that can be extremely arcane. It's very difficult to adjust these things because, generally speaking, whenever a ministry wants to adjust its regulations, it tends to get the approval of the entire Council of Ministries. It's a very centralized thing, so you go all the way up to the Prime Minister, all the way around to the Council of Ministers. The Council of Ministers issues one order and issues it all the way back down. And that tends to take a fair amount of time, and it's also just a certain level of a conservative culture that exists within these administrative processes and within this thoroughly bureaucratized state of, this is how we've done it and this is how we do it, and there's no particular interest or desire to affect very much change with respect to that. And that, I think, is really the challenge. It's not just the challenge with respect to foreign investment, it really is the challenge with any number of things. If I could point to an example of individual rights where you have the similar problems, you don't usually have a problem when you have a particular legal right that you bring to court, but you do have in the sense that I think that those legal rights can be recognized. I do think you have a problem when you're forced to go through the bureaucracy. I'm going to conclude with this example. But when you're forced to go through the bureaucracy, I think what ultimately ends up happening is that the regulations stay the way they are, and it's very difficult to get them dislodged. A women's rights example that might be a very good one is the Ministry of Interior requires a woman to get the permission of her husband or her father in order to get a passport issued to her. Pretty clear not even pretty clear, unambiguous and clear violation of Article 14 of the Constitution, which talks about equality under the law regardless of gender. You could try to defend it under the grounds of Sharia and Article 2. I think it's a pretty weak argument. I'm hesitant to talk about Sharia with Ann Mayer in the room because women's rights in Sharia with Ann Mayer in the room. But I think it's fair to say that while there are Sharia arguments that are made about a woman traveling without the permission of her husband, the idea that a woman could get a passport from her father's permission, have the passport, then travel as much as she wants, you just can't connect that very closely to the Sharia. Nonetheless, the regulation stays, and it is extremely difficult to get it dislodged, and the Ministry of Interior has been very dismissive of this idea that it should ever have to change its regulations. It sort of treats it as a fiefdom. So as I said, I think there are positive signs, there are negative signs. I realize that by doing that, I'm breaking myself out a little bit from the previous speakers. I do think the Constitution isn't as bad as otherwise depicted. When you look at it from a realist standpoint, I think the judiciary has affected realistically in terms of the vindication of property rights, and I agree with some of the previous speakers about that, the vindication of property rights, and is okay on some other rights, but the bureaucracy, the ministries, the regulations tend to prove extremely difficult, somewhat formidable and difficult to change. So I'm going to close there and turn it over to Dr. Sabah, and I'll be happy to answer questions later.
Ladies and gentlemen, it is my pleasure and honor to be here between all of you. I want to thank the University of Pennsylvania Law School and especially Dr. Ami and the National Constitution Center of course, for inviting me and for focusing on the problems that my country is suffering from. Really, when I have been asked by the organizers to select a very important challenge that Iraq is suffering from for the next decade, I directly chose the ambiguity of the constitutional provisions and its influence on the administrative framework of Iraq, which is the most important problem that we are and we will suffer from during the next, maybe the next decades. This problem its roots are extended to the fervent discussions between the new leaders of Iraq. That fervent discussion was about the shape that the state of Iraq should adopt, which is federal or simple. And in the end, Iraq has adopted a binary system, federal about the relationship between the central government and the Kurdistan region, and decentralized administration with the other 15 governorates. But the unclear provisions of the Constitution made a large number of various problems and challenges, of course, for the leaders and even for the Iraqi people. I'm going to continue the dark vision of the situation of Iraq, but I would be so practical and choose two examples to show the bad influence of the ambiguous constitutional provisions on the administrative field. The first one is about a concept of decentralized administration. Do we have really decentralized administration in Iraq about the relationship with the 15 governorates? According to the academic view, decentralization simply supposes the existing of local recognized interests run by elected commissions according to the law, of course, according to the law of the federal legislative authority or central legislative authority, according to ordinary authorities. While the situation in Iraq is something else, we have unknown type of decentralized administration because the elected commission are not compelled to be under the supervision of the central government in Baghdad. And the provincial councils of Iraq have the right to legislate laws. Any legal expert should say that this does not belong to the decentralized administration. The surprise here that the provincial councils are not compelled to obey the federal legislations of the Federal Legislative Authority of Baghdad. But while the big surprise is that if there is for any reason a conflict of laws between the laws of the Central Legislative Authority and the laws of provincial councils, the priority shall be given to the provincial councils' laws. Of course, especially about the shared specialization between the central government and the governorates. We are still talking about decentralized administration, and it is so clear that it does not belong to the academic style of decentralization. It is just like a half-caste confederacy. Anyhow, there is a problem about the mechanism. That's right, we have a large number of specialization gave to the decentralized governorates, but there is no mechanism to practice it. According to the Iraqi constitution, it says, according to 111 article of the constitution, it is talking about, 122, paragraph 2nd, governorates that are not incorporated in a region shall be granted broad administrative and financial authorities to enable them to manage it, etc. While the constitution didn't define what is the meaning of the broad specialization or authorities. So this is the problem. And that's what gave the central government a chance to challenge the decentralized administration or the wide concept of it. This envious system of administration has created, of course, several groups of challenges for our governorates and federal governments. The governorates cling to the constitutional provisions and insist that it is a very wide concept of decentralized administration. At the same time, the federal government cling to the, of course, to the decentralized administration, and the governorate should obey the central resolutions and central, of course, legal orders and laws of the center of Iraq. That's made very big problems because it's obstructed the projects of the national development, and it has weakened the people trust in the elected commissions. At the same time, of course, it's increased the displeasure feelings because of the very bad types of services which is presenting by the provincial councils, the disabled provincial councils. And it has created a spirit of challenging nowadays in Iraq between the provincial councils and the central government of Iraq. That was the first example. The second one is about the very bad influence of an ambiguous constitutional provision, which is the Article 112, paragraph first, which is talking about the federal government with the producing governorates and regional government, shall undertake the management of oil and gas extracted from present fields. I want to show the very bad influence of such ambiguous provision. It is an ordinary article, but when we analyze it, we find a very important gaps in. It is talking about undertaking the management. So the central government have just the right to share the provincial councils to manage only, not exploitation or something else, of oil and gas extracted, which means it's already extracted from the earth, already extracted during 2005 when the constitution have passed by the popular referendum. From present fields. So it is talking about the present fields, not the future ones. So this is a very big problem, which is make a huge number of troubles between the central government and the Kurdistan region. Of course, Kurdistan regional government. Really, the region, Kurdistan region, cling to these gaps of this article to be the responsible about exploitation and administrating the oil and gas in Kurdistan region, while the central government cling to the Article 111, which is talking about the oil and gas are owned by all the people of Iraq in all regions and governorates. So the government should be responsible about exploitation and the like. The very important point that these problems or challenges could not be resolved by the Federal Supreme Court, even it has the right to do so according to an article which is giving the Supreme Court the right to give explaining about the constitutional provisions. Our political leaders didn't respect the judgments of the Federal Supreme Court several times, so it is not going to resolve any problems. And the big problem is the ambiguous of the whole provisions of the Constitution. And the first challenge that we cannot amend this Constitution, it is another challenge because of the flexibility of the Iraqi Constitution, which is one of the most flexible constitution all over the world. I remember a very important sentence from a philosopher, it was Jean-Jacques Rousseau, and he told us that Constitution is the contract, is a social contract of generations. I say that this is our social problem, not our social contract. Thank you very much. Thank you, sir.
Thank you to both of our speakers. I see there are microphones that are available for those who have a question. I encourage you to raise your hand, and
Can I just make a quick
we will come to you with the microphone. As we're getting those microphones ready, I invite our panelists if they want to make any further comment.
Yeah, just one quick thing, and I guess it follows up what I was saying at the very top of my talk. I think there might be some advantages to some form of constitutional ambiguities, perhaps more than has been admitted to date. If we were to try right now in the United States to list exactly every single individual right that we think that people deserve, two things are going to happen. Number one, we're going to rip the country apart over things like abortion and gay rights and reproductive rights and I don't know what else. And the second thing that's going to happen is there's almost a guarantee that within 30 or 40 or 50 years, we're going to think that some more need to be added and some need to be subtracted. Now, there's two ways to go about that. I think one is to say, well, we just constantly keep formally amending the Constitution, which sounds like what some of the speakers want to do, just keep amending the Constitution every time things change. Or we could say, we're going to leave some level of flexibility. The Kurdish region, by reason of political histories that both Ambassador Rahim and Ambassador Surabadi have described, historical reasons, have a de facto high level of autonomy. The others don't, again, for a combination of reasons. There's no desire for it. Basra, all they needed was 10% of the population to support it, to put it to referendum. They couldn't get that. So I don't know why there's necessarily concern that this is going to happen overnight. If that desire happened among people, I think you have to trust to some extent that they're not going to do something that's just going to wreck their own country, but that they're going to follow particular predictable political, sociological, historical patterns, and that some level of flexibility and ambiguity might not necessarily be as bad as is being suggested. But that's all.
Okay, I see a number of hands up in the audience. I think this gentleman here had his hand up first. So,
Question,
if you could speak into the microphone to your right. Thank you.
was there any consideration given to the oil sharing issue of privatizing the oil fields? In other words, allowing private corporations to buy those oil fields from the government?
Those have been extremely controversial. I mean, even production sharing is extremely controversial within the South. The Kurdistan oil law actually does have a production sharing component, but the draft laws that have appeared, while they could be read flexibly to include them, generally don't talk explicitly about that. There has been some level of resistance, and I think it has to do with sort of a past in which the government owned absolutely everything of that size to broad-scale privatization. So has it been discussed? Yes. Is there political will for it? Probably not at this point.
Okay, next speaker.
Question, because this is a fault line between me and Professor Hamoudi, but I understand the business about flexibility, and I'm all for it, except you have to remember that Iraq is a strictly positivist state, so there are problems with that kind of flexibility. But even put that aside, if you have, as Mr. Gluck pointed out today, if you have a constitutional provision that says the laws of the provinces trump the laws of the federal government, but you have a provincial law that says precisely the opposite. Now, you can tell me you're just being a formalist. Don't worry about it, because the political process is working it out, and and it's not going to happen, and Basra and all of that. But aren't you actually doing harm to the rule of law when your practices are in fact not merely expanding the constitutional or extra-constitutional, but that the provincial law on that issue is actually unconstitutional.
When you were gone, I was suggesting that I was trying to sabotage your career in the State Department because I need you in the academy, because I think the truth probably lies somewhere between your formalism and my realism. But to answer the question directly, I think that you can make constructions of text that are reasonably flexible. That is to say, and I'm happy to sit with you and describe how I think that you can make the provincial powers law constitutional. I think that you would probably look at those constructions of my text and say that's a pretty contentious reading of the Constitution. And nobody at the Constitutional Convention would have when they were drafting would have possibly agreed with it. I think that would probably be true, as true as that if you went in 1868 to the Congress of the United States and asked them whether or not due process included gay rights, I mean, Charles Sumner probably caned me for even suggesting it, right? So there are developments and there are constructions of text, and language, I think, is elastic. We might disagree on how elastic it is. That could be one of the disagreements. But I do think that the power that's given to the federal government to create a provincial law, also contained in the Constitution, must grant it some level of discretion about what the form of administrative decentralization is going to be. There is a contradiction in the text. I wouldn't have drafted it that way. I prefer ambiguities to contradictions. But that contradiction, to some extent, can be taken advantage of. I don't think it's any more contentious a reading than the idea that the Civil Rights Act of 1964 has anything to do with interstate commerce. So I think that these things can be done in ways that promote the idea of the rule of law, mainly through promoting respect for the institutions that are created through the Constitution. And constitutionalism really is about respecting the various roles of the institutions more than following what ink on a particular piece of paper happens to say. But I agree it is a fault line between us.
Okay, down in the front over here.
Thank you. I don't think it's really valid to always go back to the American Constitution and say, well, look at its brevity and so on. Today in Iraq, we have a much more complex state than the United States were when the Constitution was drafted. And by the way, you remember that 13 years later, after the first Constitution, it simply wasn't working. This confederation wasn't working, and they had to give many more powers to the federal government and so on and so forth. In other words, they had to create a federation rather than a confederation. So I don't think it's really fair to go back to the US Constitution. I want to say that in those, fine, ambiguities are good, it gives you flexibility over time, but what is happening is that the federal executive, because of these ambiguities, because of the lacunae in the Constitution, is actually expanding its power beyond what the Constitution strictly allows it to, simply in order to function, and of course because every executive wants an accretion of power and wants to encroach on the powers of others. So that's one danger of ambiguity. The other danger of ambiguity is that we are going to be overburdening the Constitutional Court. The Constitutional Court, which by the way is now functioning without a law, I believe I'm right about this, could work 24/7 for the next 100 years solving problems in the Constitution. And the final thing is, you mentioned, I'm not arguing for less authorities to the provinces. I'm saying that it must be clearer because our federal executive is becoming huge when it should not be. In fact, the provinces should have more, but because of these ambiguities. And furthermore, if the conflicts between the provinces and the federal government continue, there will be more appetite in the provinces, particularly the oil-producing one, to go the Kurdish route and to become confederated. And that poses the question of what is there a federal government for if most of the provinces in the end become confederated because they're fed up with both the incompetence and the encroachment of the federal executive.
Yeah.
Did you want to reply?
Can I just, thank you very much. I want just to be sure that everyone should respect the Constitution according to its articles. We have to follow the constitutional provisions, and I want to surprise you that there is an article talking about the that what you mentioned about the exclusively belong to the central government to do. Article 123 is talking about powers exercised by the federal government exclusively can be delegated to the governorates or vice versa with the consent of both governments. So even those exclusively belong to the government, it could be practiced by the provincial councils. Yeah.
Okay, I think we have a question in the middle, the plaid shirt.
My name is Shazad Tariqi. I'm a Canadian law student here at Penn. And as you all know, there's a lot of people in Iraq that will not take a conventional bank loan. And Murabaha Microfinance has come in to fill the void. And I know Professor Ala Hamoudi is not a fan of mimicry in Islamic finance. In fact, I recently read the Muezzin's Call and Dow Jones Bell, which is a very good paper, even for a law professor. My question is, what efforts are being made to move Iraq away from being an interest-based economy?
Not many, if at all. I mean, that goes to, you know, when we're talking about constitutional constructions, I mean, that goes to the fact that one could argue that if we had a settled ruling of Islam, or however you want to translate Thawabit Ahkam al-Islam, that the interest ban could be one of them, but the reluctance of the federal Supreme Court to have anything to do with Article 2, mainly because of the fear that if they issue something about Article 2, then all of a sudden the jurists are going to have something to say, and then you might have jurists on the court. And this is the kind of crisis that they're seeking to avoid. So absent judicial sort of action, there's not really any legislative appetite. Of course, Islamist parties like to talk about interest bans, as they do in Pakistan, as they do in Egypt, but they don't actually do terribly much about it at the end of the day. I think they suspect that it could be rather damaging to their economies if they do, and so there's some level of hesitation with respect to that. If I could just one quick thing, and Ambassador Rahim and I obviously disagree on a fair amount, and I think both opinions should be thoroughly respected. To me, what you do in the creation of an ambiguity, or the way that you create a constitutionalist state, and constitutionalism is followed, is not by drafting this perfect text that sort of breaks out provisions perfectly plausibly, but it creates a balance of institutions, and those institutions compete with each other within a particular framework and a particular set of understandings. So that if the executive starts to assume more constitutional powers, and I apologize for going back to the American example, just we're in an American audience, you can talk about any number of states, no matter how positivist, in which constitutional texts evolve over time. I think it's an undeniable phenomenon, and I can't think of a single state where that wouldn't be true, including South Africa, whose constitution is relatively new. We could talk about that. But I think that what happens in these kinds of situations, in my opinion, is that to the extent that it just doesn't work, you get resistance from other institutions, and the balance of institutions sort of creates some level of an equilibrium, and that equilibrium shifts. The Constitution of the United States did shift broadly from a fairly limited set of powers, albeit much broader than the Articles of Confederation, and broader than the Iraqi Constitution, but really narrow. Into a much bigger government. And the reason that happened was because of a combination of popular will, institutional capabilities, and any number of things. And I suspect the same thing, I think the same thing exactly is what's happened in Iraq. That wasn't meant to derogate from your question, which I think was an excellent one about Islamic finance, but I just wanted to make sure I got both points in.
Okay, we have about 3 more questions and 5 more minutes. So what I'm going to do is ask us to gather all 3 questions, puts a burden on you to take some notes or whatever, and then we'll have final comments addressing those questions or any other final thoughts from our panel members. So right at the same table, please use the microphone behind you.
Alaji Toure is my name, an LLM student. My question is bordered on the Constitution and the Iraqi High Tribunal. How does the Iraqi High Tribunal fit into the constitutional arrangement of Iraq?
Okay, thank you. And then we had another question, table here.
I wanted to
Yes.
Oh, okay. I wanted to comment as an American, I've become kind of frustrated that problems weren't being solved in Iraq. It's kind of expensive to maintain an army there. We can't agree among ourselves what our goals are. But this conference, even so far, has made me feel, well, okay, you know, these people need time. That's what they need more than anything else. And how can we give them the time to resolve these issues? After all, we ourselves started with one type of government and reformed it. We had a civil war to resolve other issues. Of course, we don't want Iraq to go to a civil war, but my specific question is this. It's been mentioned several times that the Sunnis don't have the oil, okay? But Tom Friedman suggests that anybody who does have oil turns into a tyranny, end up with a country like Iran. So maybe it's a good thing that it's an inefficient country and it doesn't have oil gushing, and they'd probably start like everybody else, making nuclear weapons and buy lots of tanks and things like this, but now they're inefficient and they can't do that. They can't even probably provide their own gasoline. So that's probably a good thing. But what about those Sunnis? What is their future? Can they at least be an agricultural country that's prosperous? Can we help them that way instead of just arming them to the teeth? What is the likely future of the Sunni part of the country? Can it be made prosperous?
Okay, thank you. And our final question?
Actually, I wanted to weigh in on the ambiguity debate, and you can
Absolutely.
respond, but I'll be brief. I think you're absolutely right, Professor Hammoudi, and the intentional ambiguity, as it was described to me by the chairman of the Constitutional Commission, I think it served Iraq well. I really do. But let's be fair about what it is. It is not 125 years after the drafting of our Constitution, the Supreme Court in the midst, or the executive in the midst of the Great Depression deciding to expand on the Supremacy Clause. It is a function of the fact that at Iraq's constitutional moment, existential, critical questions about not just the identity and the nature of the state, but the very map of the state couldn't be resolved. And that's a function of either the moment occurring too soon or, as I believe, was rushed far faster than it should have been. It was a disservice. And so these ambiguities that are being manufactured now and being manipulated now really should be entrenched in the Constitution, couldn't be. This discussion, this evolving view of what Iraq should be, the way the ambiguities are being used, it's serving them well because of the failure at the time.
Okay, and final comments or responses from our panel members?
Yeah, just about the first question about the Supreme Criminal Court. The problem is that this court is belong or submit to the Council of Ministers, which is not acceptable thing according to all legal theories. All courts should belong to the judicial authority, not to the Council of Ministers, and I'm not sure about the background of establishing this court. I hope that our ambassador could add something about the matter. Yeah, but it is a court, and it is criminated the responsible about the crimes during the 35 years of genocides, popular crimes or crimes against Iraqi people, and it should be finish its work during the next period, and it would be abolished after that.
I don't have anything to say about the Iraqi High Tribunal. Dr. Salah knows more than I do, and Ambassador Sirabadi has a doctorate in specifically that subject, so I wouldn't dare to encroach on the territory of those much more learned than I in the room. On the second question, respecting the Sunnis, there's a couple things I guess I could say. The first would be that that idea of the tripartite state, as I think Ambassador Rahim and Jason and Faisal all have said, has not come to fruition. That what we have as an asymmetric federal state is a matter of reality. I mean, I think we all would agree on that. The only question would be, whether or not the Constitution, should be changed or whatever. But I mean, the point is that realistic right now, forget about what could happen and what's not going to happen. We don't have that. And so Sunnis participate, I mean, Sunni provinces have as much oil as Shia provinces in the sense that the central government distributes the money. I do share your concern, not quite in the same way. To me, it's not a question of weapons and whatnot. I think Iraqis have absolutely no appetite for war, but with other countries after the devastation of Saddam. But I do think that there is a danger with oil countries, and it alludes back to the administrative issues that I was talking about. I was talking about a huge bureaucracy, a sclerotic bureaucracy, one that takes a very long time to get anything done, one that takes a very long time, and a great deal of effort to reform, pass necessary regulations. A lot of that is the function of an oil state, because when you have a lot of revenue, as the government does, or not a lot, but when you have revenue that's sort of constantly coming in, one of the things that you do is, rather than create a small state that sort of encourages investment and encourages privatization, is rely on hiring people to sort of placate them. The Saudis have done it, and all the Gulf states have started to do this, or have done this. And there's a certain danger to that, or there's a lot of danger to that, because you end up with a government, the smartest people and the most effective people end up sitting in a government office, stamping things, and you have to go around to 7 different people to get it stamped, and then you hire the 8th, and of course the 8th needs to justify his life, so he, demands a right to stamp something, and you end up with an incredibly sclerotic, slow, and difficult system, and the number of permits just expand. By the way, that was one thing I didn't mention. You needed 59 permits when we were advising this client. 2 years before that, you needed something like 37. So, I mean, the number just seems to proliferate, and the bureaucracy is working in the wrong direction, which is unfortunate given the other judicial, the advantages that Iraq provides by reason of judicial enforcement of property rights and the like, that other countries have not enjoyed. I will, I think, close on a note of agreement with both, with actually all 3 of Faisal, Rand, and Jason by saying, and Jason particularly, you've said 2 things that have made me think, and when my book on the Iraq Constitution and these ideas comes out, I do have to credit it. I think you're all right that the Constitution was drafted too quickly, the process was far too fast, and there wasn't a great deal of public engagement. You're right, and to some extent, the ambiguity may well arise from that, and I don't think I have any disagreement with that. I think the disagreement might lie on whether or not ambiguities are a good thing or a bad thing, but there's no substantial disagreement that there were certain flaws that existed in the process of drafting, and I don't seek to deny that. I only want to challenge whether or not every time there's a problem in a constitution, whether it's the Congress can't issue paper money, or the Iraqi government can't tax, whether or not sometimes some of these solutions can be found through developing alternative constructions and developing a praxis, as opposed to each time we have to run back to amendment. But I want to close on agreement. You're all right about that point, and I hadn't mentioned it, and you're right to raise it.
Well, we may be rushed here too because of lunch. I'm sorry we are out of time, but I do want to thank our panel members here and thank all of you.